Hello, this is Ken Barron. I'm with the National Association of Black and White Men Together. I'm bringing you yet another article on the Supreme Court, or SCOTUS, as I like to call it. And this relates to the Supreme Court, and just to give you some background on the midterm and how that is super important based on what's happening on the Supreme Court. So, the Supreme Court starts again on Monday and will feature major disputes on affirmative action, voting, religion, free speech, and gay rights. As we approach the midterms, get ready for a lot of 6-3 right-wing judgments, so SCOTUS will be another reason for you to protect your rights by voting. The last SCOTUS term ended with a series of judicial bombshells that eliminated the right to abortion, established a right to carry guns outside of the home, and limited efforts to address climate change. In its new term, the SCOTUS will hear a case concerning the owner of a website design company who objects to providing wedding-related services to same-sex couples. In its new term, the SCOTUS will hear a case about many different ideas concerning race in settings as varied as education, voting, and adoptions. They also include challenges to the race-conscious admissions program at Harvard and in the University of North Carolina. As in the last term's abortion case, Dobbs versus Jackson Women's Health Organization, long-standing precedents are at risk. The court has repeatedly upheld affirmative action programs meant to ensure educational diversity at colleges and universities. Most recently, in 2016, in an interview that year, Justice Ruth Bader Ginsburg said the issue had been permanently settled. I don't expect that we're going to see another affirmative action case, she said, at least in education. In that same interview, though, she said she feared what would happen were Donald J. Trump then on the campaign trail to become president. The marquee cases of the new term are challenges to all of us. And as you know, Trump named 3 members of the Supreme Court, including Justice Amy Coney Barrett, who succeeded Ginsburg after her death in 2020. In another case, 40 years of affirmative action presidents may be at risk. The Grutter versus Bollinger 2003 decision, in which the SCOTUS endorsed holistic admissions programs, saying it was permissible to consider race as one factor amongst many to achieve educational diversity. Writing for the majority in that case, Justice Sandra Day O'Connor said she expected that, quote, 25 years from now, the use of racial preferences will no longer be necessary. The court seems poised to say that the time for change has arrived in 2 new cases, as we said, Students versus Fair Admissions versus Harvard, and Students for Fair Admissions versus University of North Carolina. The role race may play in government decision making also features in a voting case, Merrill versus Milligan. This case is a challenge under the Voting Rights Act to an Alabama electoral map that has a lower court which said it diluted the power of Black voters. In early decisions, SCOTUS effectively gutted Section 5 of the Voting Rights Act, which had required federal approval of changes to state and local voting laws in parts of the country with a history of racial discrimination. They also cut back on Section 2 of the law, limiting the ability of minority groups to challenge voting restrictions. The Alabama case also concerns Section 2, but in the context of redistricting. SCOTUS. We'll hear 2 election cases, of course, and voting maps and other power of state legislators. They may conclude that these cases all present variations on the same question. SCOTUS could announce a set of rules that together read the Constitution to allow virtually no consideration of race, regardless of the purposes or goals. And in the case of 303 Creative LLC versus LNS, could return the court to a battleground in the culture war, whether some businesses open to the public may refuse to provide services to potential customers based on religion or other conviction. The case concerns Laurie Smith, who owns a website design company, as we said, that says it serves gay customers, but intends to limit its wedding-related services to celebrations of heterosexual unions. She argues that requiring her to provide those services to gay and lesbian couples violates her right to free speech. Of course, these couples could always go elsewhere, but still, that's an issue that needs to be looked at. Let's go back to the Dobbs abortion decision. The justices in the majority disagreed about whether the logic of that ruling should require reconsideration of other landmark decisions, including one establishing a constitutional right to same-sex marriages. The new case does not squarely present that question, but the court's ruling may provide hints about the justice's commitment to protecting gay rights and, more generally, how fast it means to move towards the right. The court's recent conservative decisions led to its approval ratings to plummet. In a Gallup poll released on Thursday, 58% of Americans said they disapproved of the job the Supreme Court was doing, the highest rate since 2000. Public dissension has spread to the federal justice system as a whole, with just 47% of Americans saying they had a great deal or a fair amount of trust in the judicial branch. That is a drop of 20% from 2 years ago, and the lowest since the question was first asked in 1972. In an extraordinary series of public appearances over the summer, several justices discussed whether unpopular decisions and falling approval rates threatened the court's legitimacy. Chief Justice Roberts said at a judicial conference that he didn't understand the connection between opinions that people disagree with and the legitimacy of the court. He went on to say, quote, "You don't want the political branches telling you what the law is, and you don't want public opinion to be the guide of what the appropriate decision is. I maintain that when you go too far, too fast, people will see the court as nothing more than the judicial wing of the conservative political movement. The court has near total power to decide which cases it can hear. The court agreed to hear many of the major cases in the coming term, despite a lack of such conflicts, an indication that the new majority is pursuing an agenda and setting the pace of change. So, what are we going to do about this? The best avenue for this is for us to vote in November and help get the vote out by calling our friends, families, neighbors, and allies to do likewise. Our democracy is at stake. Please like, comment, and subscribe to us on our platforms on Facebook, on Twitter, and Instagram. You can find us at our website, nabwmt.org, and you can email us at nabwmt@nabwmt.org. Thank you for listening.